On HaloLine.com, I'm Meredith Gansman coming to you from the Legal Beat. It's Wildcard Wednesday, but just as it's a wild type of day, I'm switching things up a little bit, talking about a bit more sober of a topic, a salute to the troops overseas, if you will. I want to talk to you about a brand new exclusive CLE course done with Seyfrath Shaw attorneys Devjani, Mishra and Murphy, and it's talking about USERRA, which is the Uniformed Services Employment and Reemployment Rights Act. So take a look.
USERRA stands for the Uniformed Services Employment and Reemployment Rights Act of 1994. Broadly, it governs the rights of employees who temporarily leave their jobs for purposes of military service. It provides for protections against discrimination and retaliation, as well as reinstatement rights, and it also addresses what happens with employee benefits while they're on leave.
The key issue here is something called the escalator principle in USERRA, and this gets to what is it exactly that one is being reinstated to, because reinstatement, the very word, connotes some sort of static replacement back into the place that you were, but in fact it's well established that the returning veteran does not step back on the seniority escalator at the point that he stepped off. He steps back on, or she steps back on, at the precise point he would have occupied had he kept his position continuously.
Here what we have two potential defenses in the event that an employer is faced with litigation, or even just in terms of reinstatement. You have changed circumstances and undue hardship. These do not apply in circumstances for discrimination and retaliation. There, as we said before, the defense for an employer would be that they would have taken the same action even absent the employee's military service. This just applies to reinstatement.
A couple of things to think about in the context of your overall military leave policies, and in addition to what's under USERRA, you need to be thinking about what's available under the Family Medical Leave Act. This is again geared towards the employee whose family member is in the military rather than the military service member himself or herself. But there are these newer protections that were added a couple years ago that are still being fleshed out in regulations, and so those are things to think about. One of these is, of course, exigency leave. This was expanded in the fall of last year to cover regular armed forces, and the basic point here is that if an employee's family member is called up, is activated, you will have to provide exigency leave of up to 12 weeks for that employee to deal with the various contingencies that come with a family member being activated.
And that was Wildcard Wednesday. We'll see you on Thursday at Lawline, and from the Legal Beat, I'm Meredith Gansman. Thanks for watching. Have a great day, and it's almost Friday.